All right, welcome to the 294th District Court. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. LaRonda Alexander, cause number CR 24162, represented by Mr. White. Mr. White filed a waiver of arraignment. That's been approved. Pretrial is set October 29th. Kaylin Cheatham. Is Kaylin Cheatham here? Says he's going to be late. Okay. Danielle Gilliam. Okay, I'll write you in. Kyle Holland. Joshua Huffman. Maria Flores Perez. Jordan Manning. Jordan Manning. Braxton Johnson. Max Juarez. And I think that's a Zoom hearing request. Is that correct? Okay. All right, I'll recall that one. Jesse Lowry. Thank you, sir. Guy McSpadden. Dylan Meza. Christian Pritchett. Keith Pryor. I have, that's a custody status that he is in Polk County, so I'll recall that case. Isaiah Rosser. Caleb Waller. Ian Gray. Thank you, Mr. Muller. Juan Wilkins. Bennett Watts. All right, Mr. Watts, Mr. Millslagle filed a motion for continuance. That's been granted. Once you check in with Mr. West and pretrial release, sign your notice of appearance with him, you're free to go. So I'm not going to recall your case, okay? All right, so you can go ahead and meet with Mr. West at this time if you want to. Sign your notice of appearance and you're free to go. David Combs. Carla Brown. Charles Huff. Jeffrey Neil Walker, cause number CR 24-191-192. Mr. Schmidt filed a waiver of arraignment. That's been approved. Pretrial set November 12th. Joshua Hogue. Joshua Ernest Hogue. Mr. Hogue, I called your name. Just want to make sure you're here. Catwalla Anderson. Wesley Ball. Richard Homer. Jeremy Treadway. All right, is there anyone who's present in the courtroom and you've not heard your name called? All right, seeing no hands. Do we have any counsel that's ready? Good morning. Mr. Lowry, come on up, sir. This is cause number CR 24-171, State versus Jesse Lee Lowry. We were set previously on an arraignment, and then we reset for arraignment and status to hire an attorney. I see, Mr. Clavier, you've been retained.
Yes, sir. Just recently had James make a formal appearance.
All right. Have you had a chance to review the indictment?
Yes, sir.
Okay. Are we ready for arraignment?
Yes, sir.
All right, go ahead.
County Police Court defendant wishes to waive formal arraignment. This incident named Jesse Lowry, not guilty.
All right. The court finding that Mr. Lowry has waived the formal requirements of arraignment enters his plea of not guilty into the record. Court will set this matter for pretrial hearing. Do you have your calendar with you, Mr. Clavier?
Yes, sir.
How's October 29th? It's a Tuesday. All right, the court sets Mr. Lowry for pretrial hearing October 29th at 9 a.m. Mr. Claybria, have you already received discovery from the DA's office? Asked them to authorize you on the online portal?
No, sir, I have not.
All right. Hey, and once he signs this notice, he's free to go, Mr. Claybria.
Yeah, sure.
Yeah, whenever he's done, so I won't call him back. He gets the yellow, we get the white. Good to go. Yes, thank you, Mr. Claybria. Good to see you. Mr. Schmidt, are you ready?
Yes, sir.
David Wayne Combs, CR 2494. Believe we're set for docket call. Go ahead.
Yeah, Your Honor. I met with Frank Stanley in this case a week ago. Two new offers. In this case, we can have additional. We can, people accept one of those.
Any objection from the state?
No.
October 29th.
Yes, sir.
All right, court sets Mr. Combs for docket call October 29th at 9 a.m. Once he gets this notice of appearance, he's free to go.
Thank you, Judge. Can I be excused?
Yes, thank you, Mr. Schmidt. Good to see you. Any other counsel ready? Mr. White, you ready? Who would you like to call first? Jeremy Lynn Treadway, CR 24-8. All right, Mr. Treadway, set for docket call? Yes. All right, I'm going to recall Mr. Treadway and give Mr. White, Mr. Treadway an opportunity to discuss some additional issues. I'll recall that case, Mr. White. You want to call any of your other clients at this time, Mr. White?
Yes.
Who would you like to call?
We call Mr.
Wesley J. Ball, CR 23232. All right, this is a status hearing.
Yes, sir. We, at the last day we were here, I indicated to the court that we were going to be sending a subpoena to the DPS Garland in order to get some additional information on the testing of the DNA. We actually received that yesterday afternoon from the lab. I format, so I can send it to my expert.
All right, are we ready? You want me to set it for a pretrial hearing so that you have time to decide whether you need to file any motions? All right, court will set Mr. Ball for pretrial hearing. How much time do you expect to need?
I'm not real sure. Talking to my expert, probably, I think he's scared.
October 29th or?
That'll be okay. And obviously, I think.
All right, court sets Mr. Ball for pretrial hearing October 29th at 9 a.m. Free to go.
Yes, actually, if I may,
Mr. Ball, hang on.
I just wanted some clarification in that subpoena use that was issued by the defense to the lab, he was provided with all the DNA documentation, so I think it's stuff that we ultimately would have provided as well, but I can understand why prior to the case getting on track. But it's my understanding that all the materials were provided to Mr. White. I think we were actually to be given a complimentary copy as well, so that we know exactly what was provided. So at this point, I think all the DNA documentation has been provided at the state possession.
And I think, Mr. Hernandez, that I had issued contact, is that correct?
That's correct, no relationship.
So, I think that, that's what she.
That's correct, it was provided, as my understanding.
But obviously, if I declare an expert, then
So at this point, you believe that the defense has received all of the DNA reports from the state via the Texas Department of Public Safety?
Obviously, that's part of the reason why I hired an expert, so that we make something, as far as testing procedures and all that we need something different, but in my subpoena,
Okay, very well. All right, that's noted.
Thank you so much. Aaron.
Thank you, Mr. Hernandez. Mr. Ball, you're free to go now. The attorney's ready to go. All right. Are you ready on Miss Anderson?
yes,
Miss Holly's got to go this afternoon. See if she- Oh, it's 9:45. Okay, let me call Miss Anderson, and that'll be the last, Mr. Wise, for a bit. This is cause number CR 23-197, State versus Cat Wallace, Chantel Anderson. Motion to adjudicate. Go ahead, Mr. White.
Your Honor, part of this motion to adjudicate, the state has alleged in addition to criminal offense. I talked with Mr. Harlow this morning. I think that there, I don't know where that is for you. That information. look at it as soon as they've had a chance to review it.
Yes, Your Honor, it's still in the review process. At this point, uh, I'm not sure who has been signed for review. But I will get with everyone. Do expedite that, so that Ms. Anderson doesn't put up anything. And we'll get, with the engagement with Mr. White, what our intent is.
What's the nature of the possible new case? Misdemeanor or felony?
Felony.
All right, court will set Ms. Anderson for a status on the motion to adjudicate October 29th, Mr. White.
Yes, sir.
He is until that order's revoked. Yeah, I'll do it today. Yeah, get Richard in here and I'll we'll get both of them on the record. I'll discharge him on the record. All right, you're free to go. All right, Mr. White, is that all you have until? CR 18-311, State versus Danielle Renee Gilliam. Ms. Gilliam, if you'll come forward. All right, Ms. Gilliam is set for arraignment and on status of hiring an attorney. And Mr. White, you've been retained. So Ms. Gilliam, I appreciate you following the direction of the court. Are you ready for arraignment, Mr. White?
Your Honor, just not to plead the court. Ms. Gilliam will waive formal reading of for the indictment. To the not guilty, Your Honor. At the time this indictment was rendered, that was her name. Name is still by now. She goes by Smith. The name is correct as at the time of the offense, but the state wants to make an amendment. Sorry.
Your Honor, state would make a motion to amend the indictment of Ms. Smith's.
All right, then the court grants the state's oral motion to amend the indictment to reflect the new name of Danielle Renee Smith. Court will amend the indictment to reflect the correct name of the defendant. Does she waive the other formal requirements of arraignment in her plea of not guilty? All right, the court finds that Ms. Smith, having waived the formal requirements of arraignment, enters her plea of not guilty into the record. Court sets this matter for pretrial hearing October 29th at 9 a.m. And once she signs, she's free to go. Ms. Turner, if you'll go ahead and get your client and be ready, we're going to be on a tight schedule with the interpreter. You want to go introduce yourself and let her know who you are and that I'm going to be unappointing you? That's her. That's on Maria Flores Perez. Good morning, Ms. Beal.
Good morning, Your Honor.
Welcome Hang on, I've got your speaker turned off so nobody can hear you. Okay, now,
Nope. Testing, testing. Good morning.
good morning. How are you today?
Good. How are you, Judge?
Good. I know we've got 5 minutes, and so we're going to do this real quick and get you to where you need to go. All right.
Very well.
All right. Court calls cause number. Actually, this is a pre-filed number, unindicted, State of Texas versus Maria de Jesus Perez Flores.
Estamos en sesión oficial. Todavía no sale. Your Honor, by the interpreter, I don't see the
Yeah.
simultaneous
Yeah,
feature
yeah,
on
we're,
yet.
yeah, we're trying to get that set up. Give me just a second. Excellent. All right. As I said before, this is the State of Texas versus Maria de Jesus Perez Flores. This is a hearing on pretrial compliance. The court wants the record noted that Ms. Perez Flores had indicated that she was indigent and had requested the appointment of counsel. And the court received that application and appointed the Honorable Richard Schmidt to represent Ms. Perez Flores. And it's come to my attention that Ms. Perez Flores has now retained counsel. Is that correct, Ms. Turner?
Yes, Your Honor, that's correct.
All right, so the court will discharge Mr. Schmidt as the court-appointed attorney, and the court enters the appearance of Ms. Turner on behalf of Ms. Perez Flores. All right, and I believe that this was requested, this hearing was requested today for non-compliance on pretrial conditions. And before we go further, let me swear in Ms. Bill. Ms. Bill, as the court interpreter, ma'am, if you'll raise your right hand. Do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and ability? So help you God. Thank you, Ms. Bill. All right, I believe, is this a request to modify the conditions of bond, Ms. Turner?
Yes, sir.
All right, go ahead. What's your argument?
Your Honor, we're just asking that those bond conditions be removed.
She just wants you to speak up. She's got to be able to hear you so she can translate.
Thank you. We're asking for the conditions prohibiting her from the residence and from any communication with her daughter, her daughter's family, including her daughter's father and any other family members that assist with her care.
No, I'm gonna bring her closer and we'll get it worked out. I'm sorry, Ms. Turner. It's some technical issues. Go ahead, say that again.
Okay, we're asking that the conditions prohibiting her from the residence she shares with her daughter and her daughter's father, as well as prohibiting her from any communication with her daughter and any family members of her daughter be removed so that she may assist in the care of her child.
State.
Your Honor, we have no objection to that. However, we would ask for modification that there be no harassing type of treatment towards the children or the husband to potential victim.
Microphone, or just come on up here.
Say it now.
We'd have no objection to the removal of that condition. However, we would request a modification that there be no harassing treatment towards the two children as well as her husband while she remains on pretrial.
We have no objection to that, and I will admonish my client accordingly.
Okay, then there being an agreement, the court will grant the motion to modify the conditions of bond as requested by the defense with the condition imposed by the state as agreed by the defense. So I will get those. Have Ms. Flores Perez, I want you to remain here in the courtroom until we get those conditions prepared. Once we get them prepared, we're going to have you sign them. And then once you sign that and your notice, actually there's no notice of appearance because it's unindicted. So once you sign your amended conditions, then you'll be free to go. Ms. Flores Perez, do you have any questions for counsel or the court?
She come up here as well.
Ms. Bill, are you hearing her? Click her inline mic and make sure it's not turned off.
Quiero preguntar si ya voy a poder estar con mis hijas, si qué día puedo estar con ellas.
And the conditions that we're changing are, is you asked that she just not be restricted from being in the home. Is that correct?
Yes, as well as the school, if I didn't make that clear. She can assist with school pickup and drop off.
All right. And so Ms. Flores Perez, I'm going to allow your attorney, Ms. Turner, to explain all these conditions to you. But I believe that what you have requested today has been granted. So you'll be able to see your daughter and be in the same home as your daughter. But there are going to be other conditions upon you that you're not to harass your children or your husband while you're on charges for this case. Do you understand? Okay, all right, very well. Stay out in the hallway until we bring the conditions to you, and once they're signed, then you'll be free to go. All right, thank you, Ms. Turner. Thank you, Mr. Hernandez. Thank you, Ms. Bill. I'm sorry to keep you over your time. You're free to go. Thanks, good to see you. Y'all working on those, or is Patty doing this? Do y'all need this? Make that this motion. Oh my goodness. I don't want your stinking pants. Give me the pen. Give me the pen before I come down there. Mr. Hernandez,
Yes, sir.
can I see you real quick?
Sir.
All right, this is cause number CR 24-99, State of Texas versus Ian Perry Gray for pretrial. Go ahead, Ms. Brumlow. You may. Do you want this on the record or off the record? All right, cause number CR 24-99, State versus Ian Perry Gray. There's been a request to reset pretrial to November 12th. Any objection from the state?
No, thank you.
All right, there being no objection, court grants the request, sets pretrial for Mr. Gray November 12th at 9 a.m. Mr. Gray, once you sign your notice of setting, you're free to go. So, yeah, Mr. Rumlow? Yeah, you can just leave it up here. You can throw it right there on that table. Thank you. Yes, ma'am. Thank you. Good to see you. Mr. White, who are you ready on? Mr. Hoag, if you'll come forward. This is cause number CR 24-140, State of Texas versus Joshua Ernest Hoag for pretrial. Go ahead, Mr.
Your
White.
Honor, I filed three pretrial motions, the three that I normally file. I don't believe the state had any opposition to that. The only thing that I would be asked or informing the court on, as far as any resetting, there are two cases that are unindicted at this time. That does not mean that we may not be able to get it resolved for those cases get indicted. But just wanted to let the court know there's a possibility that there could be some delays because there might be additional discovery.
Understand. All right, then court will go ahead and set Mr. Hoag for docket call, and we'll deal with those new cases should they get indicted. Court will set Mr. Hoag for docket call. October, are you available October 29th?
You available on Halloween?
Not for this. I'll be here working, but it won't. I got evidentiary. All right.
You know, I try to avoid that after Monday.
Yeah, I don't think the Cowboys are playing, so you should be okay.
Because they're not playing most of the time.
That's true. That's true. Court sets Mr. Hoag for pretrial, or I'm sorry, for docket call October 29th. And Mr. Hoag, have you signed your conditions of pretrial release with Mr. West? You signed those? You've got those? Okay. All right. Once you get your notice of appearance, you're free to go.
That takes care of everything.
Thank you, Mr. White. And who are you ready on, sir? Mr. Johnson, if you'll come forward. All right, this is This is cause number CR 24-166, State of Texas versus Braxton Pierre Johnson for arraignment. Go ahead, Mr. Schmidt.
So, see a copy of that this morning. Wait on reading it. Johnson was present. I'd asked that he was on the peer review. Pre-trial hearing. He gives it.
Since he's just now appearing and he's not been on conditions of pretrial release, I'd rather have him come back for the next hearing. And then should we establish a pattern of compliance on pretrial release where he's drug tested, checking in, doing what he's supposed to, then I'll consider the Zoom request, but I will give you a later date in November if that's helpful.
Yes.
All right, court does enter Mr. Schmidt's appearance for the record. Court has appointed him to represent Mr. Johnson on the basis of indigency. Court enters his plea of not guilty into the record, finds that he's waived the formal requirements of arraignment, and the court sets Mr. Johnson for pretrial hearing. Are you available on November? You want November 12th, Mr. Schmidt? All right, court sets Mr. Johnson for pretrial November 12th at 9 a.m. Mr. Schmidt, do you know if he's already met with Mr. West? Yes. Okay. Sorry, I had to block out some of that. Thank you. All right, this is State of Texas versus Charles Paul Huff, cause number CR 24-181 for arraignment. Go ahead, Mr. Schmidt. All right, court enters Mr. Huff's plea of not guilty into the record, sets this matter for pretrial hearing. You available October 15th, Mr. Schmidt? Do you need more time?
Yeah.
October 29th?
Yes.
All right, court sets Mr. Huff for pretrial October 29th at 9 a.m. And Mr. Schmidt, Mr. Huff, I show that you're delinquent. It's being reported to me that you're delinquent on your pretrial release supervision fees. Have you made any payments recently? How much did you pay and when? When? No, I'm saying you said you paid $700 recently? Understand. When did you make your last payment? And how much was it? And how much was it? $100. I want you to go check in with Mr. West. They're showing me that you're close to $200 delinquent. Are you able, if you are delinquent, you can check your receipts, but if you are delinquent, can you pay that today? You can? Okay, all right, go see Mr. West, the pretrial release officer, and y'all get that squared away, okay? All right, free to go. Oh, there he is. I thought Mr. West was outside. Yeah, come on over here, Mr. Thank you, Mr. Schmidt. Mr. West is a moving target. I can't always get him.
Sorry.
No, he's doing the job. That's good. Is Ms. Brown going to be a plea? Oh, she's ready. Carla Brown, CR 07-113. Yes. You want it off the record?
Sure, yeah, it's off the record.
All right, Ms. Brown, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can lower your hand. Make sure you speak up loudly and clearly for me. Ms. Brown, you appeared before the court a long time ago, back in 2008, June 5th of 2008. You pled guilty to the offense of possession of a controlled substance, a state jail felony. On that date, the court heard the evidence, found that there was enough evidence to convict you, but the court followed a plea agreement that you reached with the state, and the court deferred a finding of guilt and placed you on community supervision for a period of 3 years. The court also assessed a $1,000 fine. It was during your period of community supervision that the state filed its motion to adjudicate and revoke, and they alleged what appears to be 14 separate counts of violations. You've been arrested on this charge, correct? And you have representation today, and your attorney is Mr. Schmidt, is that correct? And are you pleased with Mr. Schmidt and the work he's done for you? You feel like you've had enough time to go over this motion so that you understand everything that's being alleged against you? And you understand everything that's in your plea papers that you've read and signed today, is that correct?
Yes, sir.
All right. And Mr. Schmidt, do you believe Ms. Brown to be competent today to enter into the plea agreement?
I do,
And you've explained to her her rights as they pertain to this motion?
yes,
And does she intend to plead true to all 14 counts?
yes.
Okay. And Ms. Brown, I see that you have an agreement with regards to this case today. It appears that upon your plea of true to the counts alleged in the state's motion, that the state is asking that your guilt be adjudicated. That means that you will be convicted of that offense, possession of a controlled substance, penalty group 1, less than 1 gram. That your punishment be assessed under Section 1244A of the Texas Penal Code as a misdemeanor with a recommendation of 14 days in jail, with you receiving credit for time served of 14 days. And you will be ordered to pay the balance of any of the fines, court costs, and restitution that you were previously ordered to pay that have not yet been satisfied. Is that your understanding and agreement?
Yes, sir.
Okay. All right, then, Ms. Brown, I would ask you at this time, how do you plead to counts 1 through 14? Are those counts true or not true?
True.
And you're telling me that all 14 are true because in fact they are true. And Ms. Brown, no one's threatened you, forced you, or pressured you to plead true to any of these counts.
Yes, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true in evidence? All right, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense?
No.
All right, then, based on the evidence presented and the pleas of true by Ms. Brown, the court finds her pleas of true to be true. The court accepts those. Court hereby follows the plea agreement, finds that she has violated the terms and conditions of her community supervision. The court pursuant to the plea agreement revokes her community supervision, adjudicates her guilt, convicts her of possession of a controlled substance in penalty group 1, less than 1 gram. The court assesses her punishment under section 1244A as a class A misdemeanor at 14 days confinement in the county jail. The court issues her credit for 14 days of time served and orders her to pay the balance of her financial obligations, including fine, court costs, and restitution. All right, Ms. Brown, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward and be fingerprinted with Deputy Martinez here. Mr. Watts already signed his notice of appearance. Okay, I'm just gonna mark him up here. Did we put his new date on his notice of appearance? Did we put his new date on the notice of appearance? Okay, good, thank you. You, Mr. Lewis? Okay, I'm looking through my docket. I'm like, I don't know, Mr. Lewis. I bet that's him. Are you ready with Mr. Wilkins?
I am.
Mr. Wilkins, sir, if you'll come forward, this is cause number CR 24-123, State versus Juan Miguel Wilkins for pretrial. Go ahead, Mr. Lewis.
Yeah, Your Honor, I've spoken with the state, I've received all this discovery. The whole branch is made, understanding. Your Honor, I'm just unfortunately not familiar with the case on the but I have spoken with Mr. Lewis. And will be in communication with Mr. Lewis.
All right, and Mr. Lewis, you don't anticipate any contested pretrial motions?
I do not.
Okay.
I have filed those at this point. I have nothing.
Okay, but you don't anticipate needing a hearing for a motion to quash or
I don't,
suppress or anything of that nature?
not at this stage.
Okay, all right, then typically what I do, Mr. Lewis, is I will, we'll go from arraignment to pretrial. We'll take up those issues. If there are none like this case, then I set up a docket call to give you and your client time to discuss with the state and make a determination whether you're gonna want to go, trial by court, trial by jury, or plea agreement. So I'll give you that time, okay?
Thank you.
All right, court's gonna set Mr. Wilkins for a docket call. Do you have your calendar with you, Mr. Lewis?
I do.
All right, what about October 29th? You available on that day? Okay, all right, the court sets Mr. Wilkins then for docket call on October 29th at 9 a.m. And do you have a notice of appearance there, Mr. Lewis?
I do not.
All right, yeah, go ahead and fill that out, have your client sign it, and then he'll get the yellow copy. The white copy will stay with the court, and then Mr. Wilkins, after you do that, you're free to go. You're welcome. Probation, we have a probation extension. Mr. Pritchett, come forward. This is cause number CR 19-153, State of Texas versus Christian Cecil Pritchett. And Mr. Pritchett, it looks like there's a request to amend your conditions of community supervision to extend you for an additional period of 2 years. And during that period, it looks like that the probation department is willing to waive your supervision fees and your urinalysis fees. Why is it that we're needing to extend your probationary period?
Whenever I got on, I was. Just a lot of payments. I was asking for extension today, that we have to actually catch up. Now we older actually have, right. And
Okay. All right. And Mr. Pritchett, has anybody threatened, forced, or pressured you to extend your probationary period? All right, the court will approve the extension of the probationary period for an additional 2 years. Mr. Pritchett, that means that you'll now be on community supervision until October 23rd of 2026. And I'll tell you that if you'll get all of your conditions done ahead of that time, the probation department will come over and recommend that your community supervision period be terminated. And I do that at their request. If you do everything that you're supposed to, especially during a period of an extension, then I'll just grant that and we'll let you off early, okay? All right, come on over here, see the probation officers and get you a copy of this, and then you'll be free to go. Mhm. Mr. Holland? All right, this is a sanctions court hearing, cause number CR 20-291. All right, Mr. Holland, how are things going?
Pretty well.
Pretty well? Good. All right, this is a sanctions court hearing, and the last time you were in court, I ordered you to do a few things to which you complied with all. You paid your probation fee, your court collection fee, you did your 20 hours community service. You did your class, looked like you were discharged from your class and got all that done. So today, what they're recommending is that you continue along that same path. And they're recommending that I release you from sanctions court today. So since you're doing well and you've kind of established that positive pattern of compliance, I'm going to put the ball back in your court. And I'm just going to let you go out and play ball without me refereeing you as much, so to speak. Okay. So just continue on the same path that you're on and try to avoid coming back to sanctions court where I got other people I need to deal with. Okay. So continue to do well and stay in contact with your probation officer and do what you're supposed to do, and you're good to go. Have a good day, sir. You did. Okay. It's pretty good. Wish we had more like that. Mr. White, are you ready?
Yes, sir.
Who are you ready on? Who is that?
Mr. Treadway.
Mr. Treadway, come on up. This is cause number CR 24-0008. All right, Mr. White, I think the court granted you time. You needed to have a discussion with Mr. Treadway regarding, I believe, offers that were either being made by the state or counter offers, something of that nature. Go ahead.
Your Honor, this time I'm asking for this.
Okay. And Mr. Hernandez, what is the offer that has been extended by the state to Mr. Treadway at this time?
Your Honor, if we discuss at the bench, I don't know, I believe there are modification of those, so I've asked Mr. White. I'm not privy to the last offer.
Your Honor, my understanding of, current offer is 5 years for taking a felony.
All right, the court's going to set Mr. Treadway for jury selection. We'll begin that October 7th. So, Mr. Treadway, you're going to appear on October 7th downstairs. Your case will not be going to trial that day, but you're going to enter upon the court's rolling trial docket until your case is reached. So when you report downstairs, you'll see the pretrial release officer, Ms. Taberham, will be down there. You'll check in with pretrial release. You'll sign your notice of appearance, and you'll be reset. And we'll continue to do that month to month until your case is reached for trial. All right. And Mr. White, I think I told you at the bench I would likely consider setting this as a special case for trial, as a special setting. If we do so, I will consult with Ms. Taberham. We'll figure out kind of when we think that will be, and we'll notify you.
Thank you.
And Mr. Treadway, Mr. White will not be required to be here on the 7th because we're not going to be having hearings. You won't come into this courtroom, so you'll just merely check in with staff, sign the paperwork, and then you'll be excused. So Mr. White's not going to be here, okay?
Yes.
Unless he just wants to be.
Your Honor, Mr. Homer, we originally tried to we today have an issue.
Mr. Homer, come on up.
Set that for a plea.
Going around. All right, this is cause number CR 24-74, State versus Richard Kevin Homer for docket call. And you want me to set this for plea, Mr. White?
Yes, Your Honor.
All right, court sets Mr. Homer for plea before the court October 29th at 9 a.m. And Mr. White, I'm going to set this, and if he doesn't enter a plea on that day, then that'll be the final hearing. We'll place him on the jury trial docket. All right, so this one gentleman that you've got on Zoom. Reporting my Zoom. Mr. White, are you ready? Yes.
Change that date to the 29th. I put down the 20th.
Oh, absolutely. Yes, please do. Please do. Did you correct it on your client's copy?
Yes.
Yes, please. Thank you. Thank you, sir. I'm glad you caught that. Oh, you did. All right, I'm going to bring in Max Juarez for a sanctions court hearing on Zoom. All right. Good morning, Mr. Juarez. Can you see and hear me okay?
Yes, sir.
Excellent. Okay. All right. We're going to do this hearing by Zoom today. This is your sanctions court hearing and cause number CR 23-185. And when you were in court last time, I think we talked about some things that you needed to take care of. And those were paying $90 to probation. You took care of that. $75 to your court collections. You complied. I have notes that you've complied with your 12-step program, that you completed your drug offender class. All that's job well done. 15 hours community service. I think you came up short on that. Did you get any community service done?
About that, sir. No, sir, because I say I was working. I really couldn't find a spot on Sundays and everything because I was working Monday through Friday whenever I was in Henderson County. And I was hold on, let me turn off this radio. And I was gonna ask you if there's any way where I could do donations because the job I'm at, it's Monday through Sunday.
I'm gonna have to let me talk with the probation department about that, but we'll figure that out.
Yes, sir.
I'm not sure that we can
Yeah,
do that. I'm not sure that we can do that, but I'll talk with them and then we'll let you know. If not, I may have some other things that you may be able to do.
yeah. I
To
mean, I was
satisfy you.
I said what came in my mind the other day too was if I could just like do. I mean, not like do the community service hours like myself under like my own, but like kind of like give out something for the community, where it could be something for community service hours or something like that. Because I called, there's this food bank where I'm at and everything, but they close um earlier than what I get off because I work from 5 in the morning to 7 in the afternoon.
Yeah, I understand. I'll talk with the probation department and we'll let you know. Okay.
Yes, sir.
All right. So I do want to tell you that in order for you to expire on time, you do have to pay $90 a month to your probation um, all the way through December of 2026. And you got to pay $75 to court collections. Those are the bare minimums that you have to pay in order to get everything paid off by the end of your probation. Okay.
Yes, sir. That's fine. I said, now that I got this new job and everything, since I'm working in the pipeline construction, I was gonna pay it off as like within my first couple checks because I'm getting paid more than enough.
Okay, good. Well, if you pay more, then that's excellent, but just make sure that you comply with the bare minimum. Make sure you're staying on your 12-step program. And what I'm going to do is I'm going to reset you to October 29th. And what I expect to see from you is that minimum $90 to probation, that minimum $75 to court collections, and compliance with the 12-step program. And I'll tell you what, we'll discuss the 15 hours community service again on that date. Okay. So $90 to probation, $75 to collections, and compliance with your 12-step program. Okay.
Yes, sir.
All right. So if you're on the construction or you're on the job site, then just let your probation officer know, and then we may be able to appear via Zoom again. Okay.
All right, I appreciate that. And I appreciate you accepting the Zoom call because, like I said, I'm on the job site right now as we're speaking.
Yeah, I understand. And as long as you're working hard, Max, and you're doing what you're supposed to, as long as I'm starting to see some compliance and you're trying
Yes,
to do
sir.
the right thing, then I'm going to meet you more than halfway. Okay. It's when
Yes, sir.
it's when
I
you're not
appreciate
doing
that a lot.
it's when you're not doing those things that I'm not going to meet you more than halfway. Makes sense?
Yes, sir. Yes, sir. It does make sense.
All right, man. We'll see you back on October 29th.
All right, I appreciate that.
You're
Have a
welcome.
blessed day, sir.
You as well.
for restraint. I started using the Wood County has a go bus, whatever, and you have to take whatever, so I started using that last week for probation, because I have to report equipment.
Did you say you did your community service hours?
Yes, sir, I called him, that he's supposed to report it in, and talked to Mr. Griffin, he had to report it in, I won't be able to talk to him Thursday, because I'm gonna go back in and do more hours.
So you,
I've done 30 hours,
where'd you do them at?
helping hands in Hawkins.
And you did all 30?
Yes, sir.
And why did you say that they weren't reported?
I called the gentleman that is over it, he promised me to turn it in, and I found out, I believe it was yesterday before, yesterday, I talked to Mr. Griffith, and they hadn't been turned in yet. And they're only open on certain days.
Is that typical that we require the organization to report the hours? Send a sign sheet to it. Do you ever do a self-report? They bring a self-report sheet with them.
I can start taking pictures of the deal if you'll take that, because he has a logging list for everybody that comes to does their hours. We have a sign in book, and all he does is thank tax to the equipment office.
Yeah, I would recommend taking you. It's a CYA at this point.
Yes, sir.
You need to cover your own self. Okay, so I'd be taking pictures of it. Otherwise, what gets reported to me is that you haven't done
Yes,
anything.
sir. And I thought I was doing good, get my hours done, I paid my fines, like you said, and as soon as I leave here, I want to go right across the hall and take that $8 that you were asking.
Did you pay any to probation last month?
I paid you ordered me to pay $120 to probation and $80 for that. Yes, sir.
And you're saying what was the issue with that? Because they're saying probation saying you didn't pay anything.
Mhm. I have.
What about your medical information we talked about last time?
I did, I finally got an appointment at this time for October the 8th for the VA.
And is that to get your medical documents? All right, Guy, I'm gonna bring you back on October 29th, and I want the 120 to probation, the 80 to court. I want 20 hours community service, and I want all of your medical documents provided, not me, to your probation officer, okay?
Yes, Your Honor.
And, I think we had you drug tested today, and they've indicated that you were positive for alcohol, but you said that
They told me that I just, other than me drinking alcohol, I don't drink. I'm trying to do good.
we're gonna have that sent off for testing.
Yes, Your Honor.
And so I hope you're being truthful on that, because if not, that could be pretty bad for you.
Yes, sir.
All right, so we'll bring you back October 29th, 120 to probation, 80 to court collections, 20 hours community service, medical documents from your 2023 surgery. Okay, and here, I'm also going to give you some probation forms that allow you to get signed for your community service, okay?
Thank you, Your Honor. Thank you, Your Honor.
You're welcome, sir. Mr. Meza? You said he was positive for marijuana. Casey. All right, this is sanctions court hearing CR 19147. Dylan Ray Meza. Let's see, Mr. Meza, on August 1st, I ordered you to do two things, conditioned on you serving a day in jail if you did not comply, correct? We talked about that?
Yes, sir.
And we did 20 hours of community service, and it was divided up. For every 10 hours was 1 day in jail. And it says on here that you didn't do your community service. Is that right?
It may say that, sir, but I actually.
Where did you do it at, and why don't they have proof of it?
Love Action set up at Texas. The head lady is named Carrie Humble. She probably just did not send it out on hour and time. I was told by a probation officer needed maybe hours of 1 week before court work. It won't be consistent, but it is done.
When did you do it?
I do community service every Monday, Wednesday, and some Fridays. I do From 9:30 a.m. until 4:30.
And what was this place called?
Love and Action.
Love in Action.
Yes, sir.
And it was in Athens.
Yes, sir.
And Terry Caldwell is the
That's the president.
Caswell. And you're telling me you did your 20 hours.
Yes, sir. Absolutely.
All right, so this is what I want to do. I need to get to the bottom of this, but I want to do it today. So I want you to come over here and Mr. West, one of y'all help me out and see if you can make contact with Ms. Caswell and get some kind of verification on that. So come over here, Mr. Meza, have a seat in the back. Let's get this figured out because it's going to make a difference to whether you go to jail or you don't go to jail. So it's very important. Where's Mr. Cheatham? I don't see Mr. Cheatham. I thought you said he was here. Huh? Oh, he's waiting on him to give a sample for. Mr. Waller? You, Mr. Waller? What's your name, sir? Huffman? Do you have a lawyer? Oh, yeah, Mr. Huffman, come on up. This is cause number This is cause number CR 24-165, State of Texas versus Joshua Stephen Huffman for arraignment and status of hiring attorney. All right, Mr. Huffman, have you had an opportunity to contact some lawyers?
I've been calling around, they're just so expensive, I just don't have the money right now, but I'm working on it. I have one, he wanted $100 to, he's supposed to represent me. Which is the messages, I guess. So I have no idea. His name was Kevin Allen, Terrell. I was like, so I haven't heard from him really, so.
And you said you wanted $100?
Yeah,
That's all?
that's what I said.
That doesn't sound right, Mr.
Yeah, I
Huffman.
don't know if I was just for like, just.
Now that might be. I mean, he could charge you $100 to talk to you on the phone to find out more about your case.
But I got paperwork right here. Sean. I've been looking,
Mr. Abraham, go ahead and get his paperwork. Let me see.
yeah, I've been looking around. Cheapest one I saw was white over there.
Do you have any money? Do you have any money saved up?
No, sir, well, I'm working on it. I'm supposed to have some money coming in. So,
How much money?
at least $500, maybe 6, I think.
Do you have land or a house?
Well, I own this land, but I'm trying to sell it to my dad, so maybe I can make some money off of him.
Have you been trying to sell that to other people than your dad?
No, sir, I don't really want to sell my land, live on the streets.
Well,
I know.
you could not sell your land, and end up representing yourself and end up in jail or prison.
No, I don't want to do that. That's like the last thing I want to do, you know, in the midst of like, I got to come to some. I don't even have justification. What was I, what was my? What my first opinion was? Yeah, it's my first, it's,
So you're keeping your bondsman paid.
yeah, I'm trying. I've got money for probation too, I just gotta get to that.
How much land do you own? How much land do you own?
It's a 3-bedroom house.
Is it paid off? Have you considered using that as collateral to get a bank loan?
Into that too long.
Well, it's not hard. It just takes effort. So that means you need to get on the phone and you need to start calling banks and find out how much money they'll lend you against your collateral land. And that will tell you, that will give you the opportunity to hire some of these attorneys. That'll then give you the opportunity to have someone represent you.
See, I'm waiting for a FEMA check.
Well, you can get that money and you can give that to the bank.
That's what I'm thinking.
So, Mr. Huffman, I'm gonna reset you one more time. All right? I'm gonna reset you to October 29th. Are you working? Are you working?
Yes, sir.
Where do you work? What do you do?
Well, I was doing trash for my brother-in-law. Revolution Cycle. But he's slow lately, so he doesn't work 2-3 times a week. But when I'm not working with him, I'm doing like side jobs like mowing grass, construction.
So I want you to remember that the reason you can't have a court-appointed attorney is because you have an asset that's worth several thousands of dollars. And that prevents me from appointing you an attorney because it wouldn't be right for the taxpayers of Van Zandt County to pay for your lawyer when you have an asset that you can sell and pay for your own lawyer. I understand you don't want to sell your land, but we all, as adults, have to make choices when we have priorities. And your priority is going to be determined, do you want to keep land or do you want to represent yourself against some trained lawyers in a criminal case that could put you in prison from anywhere from 2 years to 10 years in prison? You don't want that. So my recommendation to you is that you have this asset, you have this land, you need to go out and find a way to leverage that to get the cash that you need to hire one of these attorneys and have them come in here and help you figure out how to resolve your criminal business. Understand? So I want you back on October 29th, and I expect you to have done what you need to do to take care of your business, to have an attorney. All right. So if you come back without an attorney, then the discussion we're going to have is whether or not you should be on bail. Because if you're not following the court's orders and you're not taking the steps necessary to move this case along, I may find your bond to be insufficient and you won't need to be paying your bondsman anymore because I'm going to increase your bail, put you back in jail, and then we'll go from there. All right. I don't want to do that, but I need you to do your end of the job. All right. Free to go.
Thank you so much.
Wait on Mr. Cheatham. And Mr. Juarez, we put him in sanctions court on 10/29, right? Also. Did you get some information for me?
Is, just waiting on your response.
Okay. All right, let's put this on the record. Cause number CR 15-322. State of Texas versus Keith Pryor. I believe that Mr. Pryor is still in Polk County, Florida. Any update from the state on your prosecution of Mr. Pryor?
Your Honor, I apologize. I get a few minutes.
Okay. Go ahead. And you said Mr. Waller's drug testing too also. So to answer your question, I don't believe we had any no-shows. Did you message it? All right, Mr. Mesa, I'm gonna have you come back on October 29th. I expect the same thing. We're gonna do 20 hours of community service, and that's going to be 1 day in jail for every 10 hours not completed. So you're looking at a maximum 2 days in jail for October 29th. We're gonna verify your claim on your completion of your probation hours, your community service hours. And so if it comes back that you didn't do it, then you're gonna have 2 days in jail for that as well. So on the 29th, you have 20 more hours to do. If you don't do those, for every 10 hours you don't do is a day in jail. And then we're gonna verify your other story. So at most, you could be looking at 4 days in jail when you come back, okay?
And, one thing, but my monthly fees, the only reason why I opted into that for these months is because I worked with Tom the months ago, and then I got hit with a sidetrack, and I put my phone in the process, and then during work with Tom, you don't get a check till we get 60%. So kind of set it back a little bit, you know, work, I got my hand though, I just got my stitches taken down about 2 weeks ago. And I also set it back another week of way less pay. So that's the only reason why when I left pay probation, because I was, it set us back behind on bills and daycare alone is $750 a month. I was making about 37 a month whenever I didn't miss any days. Now that I miss quite a bit, about $2,500 a month. So that's the only reason why I was thinking that 100.
All right. Well, I appreciate you telling me that. The probation department, because you still have a significant period left, you know, till 2030. The delinquency, they're noting it. I see it, but it's not a high priority until that amount starts to really creep up there. And so they're going to give you a little bit, they're going to give you grace. And when you fall behind, and especially in your case, we see that you've already paid your court collections and some other things. And so they're gonna give you that grace and give you a chance to catch back up. That's why I'm not saying anything to you about money, but I appreciate you being forthcoming about being delinquent and what the issues were. So I do appreciate your honesty in that. It's not a super concern to me right now. If that delinquency started creeping up, if it became 120 every month and all of a sudden we look up and you're $500 or $600 behind, then that's when we'll start saying you need to pay more each month. All right. So right now it's your community service that we're trying to get you caught up on. Make sense? All right. So we'll see you back on October 29th. She's got a form for you. All right, so y'all will follow up on that. Take care. So we have Mr. Cheatham left. Yes, sir. You as well. We have Mr. Cheatham, Mr. Waller, right? Which one? You can just say restaurant. I'm gonna take a break just a second.
It's pre-trial, but
I'll, let's look. All right, this is sanctions court hearing for Caleb Wayne Waller's cause number CR 23-42. Mr. Waller, this is your first time in sanctions court, is that correct?
Yes, sir.
All right, do you understand what sanctions court is and the purpose?
No, sir.
Do you have any idea?
No, sir.
Okay. When you were originally placed on probation in March of last year, correct?
Yes, sir.
And I think you were put on for deferred adjudication for a second-degree felony offense of aggravated assault with a deadly weapon. And as part of your probation, you had all of your conditions that you had to comply with. And one of those conditions was that you have an interlock or a toxalock on your vehicle. Is that correct?
Yes, sir.
Some of the other things you gotta report, you gotta pay, you gotta do your community service.
Yes, sir.
And I had a note here that you were locked out of your interlock device on June 29th of 24. And then you had to have one installed after you were placed in sanctions court on September 6th. Is that correct?
Yes, sir. But I have no recollection. That first lockout, I never put on that.
Okay. And it looks like you were behind on your community service and your court fees.
The community service, yes, sir. I live over in Tulsa, Drive. I just recently transferred to Henderson County. There's a lot more options for me to be able to knock out the community service a lot faster. And so being over here, I was only been able to do that once a month at the first Monday around. And that's my thing. Well, I got a little behind, and I think 3 of those were because I had coronavirus. I had 4 kids all the time, so that it just it didn't work. And I'm trying to get back ahead on fees and everything. Everything should be caught up. Being sure before I would come to court. If that's behind my opinion.
You believe that you're current on your
Yes, sir.
probation fees?
Yes, sir.
And what is your typical probation fee each month?
65 for probation and 45 for health.
Can you verify for me whether or not he's current? Because it'll determine what I set him at next week. All right, so I'm gonna have Officer Matura verify whether or not you're current on your fees.
Yes, sir.
But I want to tell you, the purpose of sanctions court is whenever we have someone on probation and we start seeing some violations or we start seeing some people falling behind on their requirements, then sanctions court is it's an intervention program. It's where the court tries to intervene to prevent people from getting so far behind on their fees or community service or any other technical violations that puts them in a position where they're likely not to succeed on probation. And it's an intervention with a policy of trying to become corrective, and that if you have to pay $60 a month and all of a sudden you're delinquent, you miss several months, then we're trying to stress the need to pay more so that you can get caught up, so that you don't end up getting a motion to revoke, a violation report being filed on you that then puts you in a situation of being locked up and having hearings and determining whether or not you're still a good candidate for probation. So really what it is in other words, is an opportunity for the court to try to get your attention and say, hang on, what are we doing here? Why are we falling behind on our community service? Why are we falling behind in our fees or whatever issues, education, whatever the issue is? For you, it looked like, okay, you started falling behind in fees and you started falling behind in community service. And we're trying to correct that and make sure that you understand that failure to correct that's going to end up in a violation and a motion to revoke. So current, okay. And so you said that you've recently transferred to Henderson County? All right, and okay. And do you have a plan as to when you're going to do your community service? What is that? What's your plan?
They have
have a fishery. They have the Human Society.
What's your plan? I know what they have, but what's your
Oh,
plan?
no, that's fine. They're trying to knock out as much of that's like.
And so like, is there a certain day of the week, a certain time frame you're doing it?
Saturday and Sunday from 8 a.m. to 5 p.m. Much like that.
And you said that, do you have a job?
What's that?
Do you have a job?
Yes, sir.
You work Monday to Friday?
Usually it's Monday to Friday, daily Saturday.
What do you do for a living?
Construction.
What kind of construction?
I build boat docks and remodel house.
Okay. All right, so what I'm gonna do, Caleb, is I'm gonna have you come back on the 29th. And I want you to pay, I want to see that you've paid your 65 to probation. Do you know what his court collection fee is? Because it says 100 here, but if he's current, I don't want to have him paying more. Can you ask real quick? Do you know what your typical court collection fee is towards your fines and court costs? It's 45. So you're paying 65 to probation and 45 to court collection?
Yes, sir. 100%.
All right, I want to see 45 to your court collections, and I want to see 20 hours of community service. That's really where you're the most delinquent, is in your community service, and maybe having you in Henderson County is going to clear that up. So let's do 20 hours, and you should be able to do that without having to do that all weekend every month. And so I want all of those things done, and I want them turned in to your probation officer. And you're reporting over there. Are they open on Fridays over there?
Yes, sir.
I want you to get this turned in the week before you're scheduled to come back here.
Yes, sir.
The week before. Have all that in. That gives us time to get the reports from Henderson to here and to me. All right, we'll see you back on the 29th. You're free to go. 45?
Yeah, because
How much are his fines and fees?
he has like a 730.
Oh, I thought you said he was current on all of his
He's
fees.
current on probation.
Oh, not on court collection. Well, we'll have to adjust that next time. So I'll just go with $45. Because I thought he was current. And that's what he said his fees were.
Yeah.
Smart. Okay, so we got time to catch up with him. All right, this is cause number CR 15-322, State of Texas versus Keith Pryor. Mr. Pryor is in custody in Polk County, Florida. Go ahead, Mr. Hartwell.
Yes, Your Honor, I spoke with Mr. Bennett, who is the prosecutor on Mr. Pryor's case in Florida. He expects that this case is going to resolve with some sort of a time served type offer. So at this point, Your Honor, the state intends to maintain motion to adjudicate and would like to be more active more than it so that he can meet Mr. Pryor and issue over.
We know if we have a detainer on him.
Your Honor, I'm not 100% sure. I can look into how I would verify that.
Yeah, if you don't mind, because if we need to do a detainer and he's on bond, then the court will need to address the bond issue in order to get a detainer.
Yes.
Did he give you any kind of idea on when Florida may be done with him?
He did not. He just indicated how he expects it to resolve, but he didn't give me so I'll keep in contact with him, and he did say that as soon as it resolves, he would send me a copy of those. So I should have an idea if not beforehand, at least shortly afterwards.
All right, let's set Mr. Pryor, let's set it out a little bit. We'll set it out to November 12th. All right. We're gonna wait. We have one more sanctions court hearing, so that's all we have. So you are free to go if you want to, and we'll see y'all at 1:30. All right, that does conclude this morning's criminal docket. Courts in recess till 1:30.